think we're, oh, there we go. There's my other one. All right. So just to let everybody know, well, let's see. First off, small roll call. We do have, it looks
Gina's
like
asking for
quorum.
a second.
Oh, okay. I don't have my dual screens, so I have to keep flipping back and forth between the agenda. Oh, and we have Tashonda.
Run through a couple.
Well, I know if we're waiting on Gina, I think I can at least note for the recording that we do have myself, obviously Josh has made Gina and Tashonda present, so we do have quorum. I will note that a copy of the September 26th meeting minutes have been posted to the task force website. So if anyone has any corrections or additions or anything like that, please speak up. All right, not seeing any objections, they are approved. So there we go, we got those out of the way. Gina, do you still need a minute? Well, why don't you just share your screen with the document so everybody we'll take a moment for everybody to look at it and read it. And then once I guess everybody's ready, we can start.
Madam Chair, it looks like I'm in read-only mode. Would you like me to mess around so I can get in an editing mode?
Yeah, we may need that.
Okay, I'm going to stop sharing for a moment then.
Okay, yeah, because then maybe we can kind of do one of our working documents. All right, good morning, everybody.
Hi, everyone.
So today we'll see if we can hammer this out kind of as quickly as possible. I know we already met on Monday, so we've all devoted quite a bit of time to the subcommittee this week. So thank you everybody for being here today. I think this is kind of the last piece for our subcommittee, and so it's obviously important to just get it done.
And Madam Chair, I apologize. This is taking me longer than I thought it would, but I will let you know when I get this open.
You're fine.
There we go. Enable editing. Had to reopen it. All right. Come on, where are you? There we go.
Okay, so this was as just to kind of circle back and let everybody know where we're at. So now we've been focusing on the process. Last time around, I think we came with some good recommendations for accountability. And so now this really last piece we're looking at is the actual process itself. And so Josh put together this very helpful bullet points of certain portions or certain pieces of the process to kind of help us understand and come up with suggestions. And so the way we did it was we've got the bullet points and then the things in yellow are just some of these suggestions that Josh and I talked about. So if there's no yellow, I think we kind of decided that that maybe there's not necessarily a recommendation that comes out of it, but at least we want to make sure we're touching on it. So, and Josh, if you don't mind, since this was your document and you were the one that was really looking at it, I'm going to let you kind of take over a little bit, if that's okay.
I certainly can. Do you want me to run through the whole thing again? I don't, I guess I'm
No,
not
I mean, I
entirely
guess,
sure, what we want to try to accomplish.
Yeah, no, that's okay. And I guess maybe just Gina and Tashonda, since Josh and I already went through this, are there any specific questions that you have or is it helpful for you if we go through each of them quickly? I guess what will help you guys? Okay.
Yep.
Okay.
I want to understand what I'm looking at.
Yep, fair enough. Okay, so yeah, each bullet point was at least the initial bullet point, not the sub bullet points, is sort of like Lucas said, like an issue that we had already sort of flagged as something we wanted to think about, or something that I think a few of them are just things that I came up with as I was reviewing the statute and prepping for the meeting earlier this week. So the first one is one of the things that that we had been talking about is that it's sort of odd that the appeals process, once you have a decision from DHS on whether they're going to grant a set aside or not, your next sort of appeal is to an administrative law judge or a DHS judge. And it's a little bit odd. I've always found it odd that it depends on the kind of job that you're applying for, whether or not you go to an administrative law judge at the Office of Administrative Hearings, which is sort of outside of DHS, or whether you go to a DHS judge, which fulfills sort of a similar role, but is still within the department itself. I did a bunch of digging to see if I could figure out like what routes you to which path. And basically you end up with an administrative law judge if you're disqualified under 245A, which deals with child and foster care, and then residential and non-residential like group homes and treatment programs. And then you have a DHS judge if there's anyone else. I still think that's kind of weird, but I don't really know, just from my reviewing the statutes and stuff, I don't really know what the rationale was for the policy decision to separate it out that way. So it's a little bit hard for me to recommend that we change it. And I don't know that it makes that big of a difference in the long run, which type of administrative judge reviews the case. So I flagged it as something I've been thinking about, but when we talked about it on Monday, Lucas and I didn't really have, a firm recommendation as to whether it should be changed or not.
Do we want to ask DHS?
We certainly could.
Like, what's the reason?
Mm-hmm.
Well, I think that's probably more of a
my guess is
statutory.
licensing. That's if just looking at it, it's about licensing. That foster care and child and foster care, that's licensing, and residential and non-residential programs, it's about licensing. If it's licensed, it goes through administrative law judges. If it's not, it goes through DHS.
So, but that doesn't necessarily explain why it would be that way, right? But yeah, I think you're right that that's why they're sort of two different buckets, but the reason that the two different buckets are treated differently, I don't really know what the answer is. So moving through so
you're just flagging it for consideration and we don't have enough information to make a decision about it. And given that, do we really want to add it at the end, or you just want to flag it, or tell me what you want to do with it?
I wanted to flag it so that we could talk about it. And Lucas and I did have that discussion a little bit on Monday's hearing. but yeah, in the grand scheme of things, you know, I don't know that I am confident enough that it's even a like I don't even know that it's a problem, essentially. Like to me, it seems like a weird artifact of the statute that doesn't make sense. And maybe it's just my like OCD brain that's like, why would this be different? This shouldn't be different. Like it, you know, I guess to the extent that it's a problem, it sort of, it maybe creates some confusion or, you know, some uncertainty for people going through the process, you know, how their appeal might play out. But, you know, at the end of the day, it's still a similar hearing in front of kind of a similar decision maker. I don't know that it makes that big of a difference. And not being confident that it's even a problem, I don't know that I want to be making a recommendation that's going to be hard to defend, and that might distract from other recommendations that I think are more important.
Okay. So time for appeals.
Yes.
And by appeal, do you mean set asides?
Yeah, this is the time frame that an applicant has to request reconsideration.
Mm-hmm.
Yeah.
What does good cause mean?
That if you are out, so first of all, the first recommendation is to get rid of the 15-day window altogether, so that they're all 30 days.
See that.
The second one is if you are outside of 30 days, that if you can show DHS that there was a good reason that you missed it, right? You didn't get the notice, or you know, you were sick at the time that you got it, or, you know, whatever it might be, that DHS should extend the request for reconsideration period upon that showing by the applicant that there was good cause to miss the 30-day deadline.
Mm-hmm. Awesome.
And then the third one is Lucas's idea that the notices go out by certified mail, if not personal service.
Yeah. Yeah. I feel like that suggestion is great if we're gonna, as far as process, not recommend that they have a digitized way to do this, because if it was digital, we would, like, they could just email you, right? It could just go through a portal. It could just, right?
I think my concern would be, though, like, just from a legal perspective of, I mean, so many clients don't watch their email as it is. I'd actually be more worried about more things getting more people missing it. And then versus, I mean, to me, you can do it by both, but with the certified mail where somebody literally has to sign for it, I would be nervous about all electronic. And I think there are plenty of people who just, I mean, you think about somebody who's homeless or just doesn't have access. If we're looking at, you know, may not have a computer, they may not have internet.
Where are they getting their mail if they're homeless, Lucas?
No, I get that, and
Those
that's
are the
probably not the
people that
good
are
example.
missing
But
the
I'm
mail.
just thinking, even just like having access to internet, I think you're gonna. To me, I would not want all electronic.
What if the applicant could opt into electronic?
I think maybe if there's a way to opt in, but I guess the other problem would be that then that's a whole system that, like, that's a whole software and processing system. Think about, like, who's going to operate that? Is that DHS? Is that, I mean, what kind of system are we talking about here? Is this like the court e-filing system? Is this just the email gets sent to your Gmail? I guess I'm not sure what because then that's a whole other infrastructure.
And it should be.
I'm
It
not
should
saying it
be.
shouldn't. I just,
They
I
need
know
to get into the
some of,
21st century. Like they just made the pardon application process digital. You can turn all that in. Like, and it shouldn't be a paper process. You shouldn't have to drive down to DHS to hand in your application so you know that it got there. Like that, it's the 21st century.
yeah. Well, and
And-
then I suppose it's because a lot of it is confidential data. I wonder, I mean, I guess maybe we make the recommendation that they look for some sort of a system. Because it'll have to also have their protection for personal, because it's confidential data. None of this is public. So it's got to be something that like only that person, I guess, has the login information for. I don't know. I'm just thinking out loud.
What do you mean none of what is public? Most of what you're turning in is public information.
No, but disqualifications, if you think about it, as private data.
But you're not
So the Data
turning
Practices
that
Act.
back in to them. Like what I send back into the DHS is all, real talk information they should be able to get on their own. Police
Well, and
report.
we have that later on, but your request for reconsideration and all of that's confidential. Yes, your attachments may be public, but your actual portion is confidential. It's a confidential process. So, but yeah, I think it'd be great to suggest that they look into some sort of an electronic system.
Because this time frame would be much different if it wasn't a snail mail process, right?
Well, if what we're really talking about is being able to submit your request to reconsideration to DHS by email. That's not something that needs a whole new technological system. They have email addresses. They have someone who can check the email address and move the document from the email to their workflow file as it already exists.
It would be nice though, like, Minsis, where you as the individual can log in to see like dates that certain things happened and stuff like that. Like you can log in and see they received it.
Well, we have the bullet point a little bit further down about accessibility. Our main suggestion there was to create a way to go through the process without needing written submissions, so some kind of interview process. But maybe some language there that asks DHS to make it easier for those who want to submit documents and correspond with them via email.
That's good.
Yeah, I definitely wanted to talk about that when we got to the conversation about process. Because that's one of the biggest things, like having gone through this process as many times as I have, like it's the 21st century. Like we need to get this and maybe there are some things that like we have at Teen Challenge, we send and receive information like assessments, which is medical information that's HIPAA protected. And we do that digitally. We have software, we have email, zip files or whatever, sync files, or it's not possible, right? And it makes it so much easier for clients to be able to do all of that. When you're talking about like people that are homeless and don't have access to stuff, like most people have a cell phone, and to be able to do all of this via your cell phone or at the workforce center, or people are applying for these jobs that they're being background studied for in some sort of digital way. And And so I think expecting a place for something to be mailed to is actually more of a stretch than a digital option.
Okay, well, I think, are we in agreement on those suggestions then? Should we keep moving?
Yeah.
Do you feel good?
Mhm.
Okay. So the next one, as a part of the application process, DHS typically asks people to get copies of their police reports and then submit them to the agency. That's very, very difficult for people to do, and I've never really understood why that seems to be necessary, since DHS also seems to be able to get the police reports on their own. So our suggestion here is that instead of putting that unnecessary burden on the persons seeking the set aside, DHS gets the reports themselves and provides them to them.
What? Did you just say they also get those reports on? Did you just say that? They also get the reports?
Yeah, the DHS has ways to get the police reports themselves if you don't get them.
But they don't get them also anyways.
I think so. When I've gotten the cases that I had that went up to the ALJ appeal, DHS had a big discovery packet that included all that information that they gave to me.
Okay.
So you're okay with this suggestion then?
Oh, yeah, I am very okay with it. Why would they send people running around to get police reports if they're just getting them anyways?
I don't know. If I had to guess, my guess is that they don't, as a matter of course, get police reports for everybody. They get them once they need them. And might be easier for their workflow to have people get them early on, and then maybe DHS doesn't.
People maybe just give up when they have to get the police reports, and then they don't have to do it at all.
Well, I was trying not to be that cynical, but that is also a possibility, that it is a process roadblock that is,
I didn't have a car my first time, and I had reports in Goodhue County and Scott County and Washington County and Ramsey County and Hennepin County. And I had to go get all of those reports within 30 days and get it done and get it in. It was, I think I still have a little like trauma about the stress of it all. And so the fact that they like maybe had them themselves to.
Well, whether or not they had them at the time you submitted your request for reconsideration, I think it's really clear that they have the ability to get them.
Got it. Huh.
So, and then a companion suggestion is, if DHS can't get the reports prior to issuing the disqualification, then that 30-day window for requesting reconsideration doesn't start until DHS provides the police report. So the idea there was not to create a barrier that makes it harder for DHS to issue their initial decision for people, because that already can sometimes take a really long time. But then also not put people in a position where they don't have that information when they're filing their request for reconsideration. The next bullet point has to do with waiving the appeal issue, waiving the request for reconsideration. This is a recommendation that doesn't matter a whole lot if we end up getting rid of preponderance of the evidence determinations altogether. But it is a major problem for people who have preponderance of the evidence based disqualifications under the current system. If you don't appeal within the allotted time frame, you waive your right to appeal it, and those issues become final agency determinations. And that's not a huge problem if all you're asking for is a set aside, because okay, so you got a final agency decision that you're not getting a set aside for job A, but you can always apply for job B and request a set aside in connection with that new application. But if what you're asking is to challenge the accuracy of the agency's determination that you committed a disqualifying act based on that preponderance of the evidence standard, then if you don't challenge it the first time you're disqualified, that part becomes final and you've forever waived your ability to argue, essentially your innocence. So if we don't get rid of the preponderance of the evidence determination, if that stays, then I at the very least want to recommend that we change the language so that that issue is not finalized until somebody has actually challenged it and lost the challenge. They can't lose it just by failing to respond on one disqualification.
I really like that. I can't speak for everyone, but I can say that, when it comes to the POE standards, most that are considered, being accused of committing a crime or a disqualifying act, they're not intending to do so, or they don't realize that's what's happening. So, and we know there's other factors involved as well, right? In regards to perception. However, to be in that predicament, you've never heard of set aside, and to even know to request such things, let alone process that you're being accused of committing a disqualifying event and not knowing the evidence against you, the evidence that's been gathered against you, if there is any, right? So I like the way you said that, Josh.
Awesome, thank you. So the next one, I thought about making recommendations about the time that it takes DHS to turn around their very first decision, whether or not to disqualify someone or not. Anecdotally, I've seen these like hang out there for a long time for some people. We talked on Monday about whether we wanted to make a recommendation on that. I mean, we certainly could. The reason it's taking so long is clearly, DHS being overloaded. And so any recommendation here is going to be like the kind of recommendation that's like, okay, well, that means that we need to, increase our staff by, 80% or something, which just might not be possible. The other reason we didn't make a recommendation is this part actually isn't always bad for the job seeker. DHS actually does usually issue the disqualification really quickly if they think the person is dangerous. But if it's unclear and they haven't gone so far as to make that dangerousness decision like right off the bat, oftentimes people actually can get in the job and end up working for months, over a year sometimes. And then now, assuming that time has gone well, which, if the person is still in the position to get a set aside a year later, at the very least, it means the employer still wants to be working with them. Mm-hmm. Then they're in a position to, demonstrate that successful work history as a part of their request for reconsideration, which actually could help avoid the disqualification altogether. So kind of for those.
I'll call that mitigating, right? Mitigating factors.
Yeah.
A year of employment. I feel like these bullet points where we're not making a recommendation could be really good places for us to just put in like data and information, right? Here's what we found. Like anecdotally, we have people who can sometimes wait 6 months and a year to hear back from DHS at, initially, or it can take it varies from a week to 3 months to hear back initially. And, these variable times can be because of this can just, we don't need to make any recommendation necessarily. We can just point out the flaw, right? Here's the key challenge, right? Here's the data. And then the legislature can do whatever they want with it. But I think it definitely is an area where like it's part of the problem, right? And that if we can eliminate some of the background studies and the backup, that it will help with all of these other areas. And so I think probably just pointing it out and not making a recommendation in that area is a good idea.
Awesome. We're on the same page then. The next bullet point relates to the statutory timeframe that DHS has to respond to your request for reconsideration. And it varies by what issue you're asking them to look at. So it's 15 days if it's just a risk of harm set aside request. It's 30 days if you're also challenging the correctness, like a preponderance of the evidence determination. It's 45 if it's both. I think we didn't see any reason to adjust those. And as far as I can tell, DHS does hit these marks, at least anecdotally in my experience. So
I do want to just say with that, because in my experience, that was not the case.
okay.
Because I guess it's, I can't remember if it was 3 years or 4 years, that if there was some, in regards to me getting my licensing, foster care licensing, it was, again, I can't recall if it was 3 or 4 years, but anything beyond that, they're not supposed to factor in. And then they took a report from my oldest daughter's school that was like 5 or 6 years prior to, and that was their basis of trying to make that determination.
Okay.
So DHS response times from the
So this is
after the
after
set aside?
after you've submitted your set aside, or
So this was prior. So in my situation, in my circumstance, I had received, I did the kinship, I received licensing. And then when I had that slanderous event happen, that's when they then looked back and did like another review, if you will, and then looked to see that I had a family assessment with my oldest daughter. It was 5+ years prior, and then was saying that allowed them to
Reoccurring.
determine,
Yeah.
that it was reoccurring.
Yep.
In that.
I'm so sorry
was-
that happened to you, Kashonda. That just sucks.
I mean, thank God I got, it was, thank God it's not on my record, but it would have been, had I not had resources.
Right.
But yes, I just wanted to say that no, the timeframes are not honored. They're not.
Yeah.
okay, so,
So-
we definitely
so this is-
we need a
Yeah, this is
recommendation.
not accurate though, Josh, because we've had people wait after they're set aside for a year to hear back from DHS.
Okay. So these timeframes are already laid out in the statute. So the statute
Yep.
requires DHS to meet these timeframes.
And so what happens if they don't then?
That's
So
the
like,
thing,
let's
there's no-
talk about
That's the issue.
accountability. Yep.
And see, that's the issue, because first of all, with even getting my appeal, they wasn't following timeframes even with that. And I have documentation for all of that. And so then when you talk about accountability, I had the statute of limitation had exhausted in time for me to then state all these factors where the department did not follow statute. But because the statute of limitation had been exhausted, there was nothing I could say at that point. So I just imagine how many other people are experiencing that and can't bring it forth because they're outside the 10-month statute of limitation.
And so I don't know what the recommendation would be on that, Josh. Like I think about, if they can't figure out, like, I know this isn't going to be popular, but if they can't figure out your firearm stuff within 3 days, you get to just go pick it up, right? And so like, what is the thing? If they can't get it done in 45 days, like you just get to work, or like, how does that work? Because I'm telling you, I had a guy that it was a year and 3 months before his DHS background came back. And that's an outlier, right? But it is not unusual for us to wait 2, 3, 4 months for they send a letter that says, need more time, work with supervision, work without supervision. But right now, with them being 100,000 background studies behind, like, it's
I see.
months.
So
It's
so
months
they
before we hear back.
they respond within the window, but not with a decision.
Yep. Yeah, need more time. That's the letter we get within these windows. Need more time, unless it's a quick decision.
And in your experience, do those typically come with some like allowed to work with supervision type thing?
I mean, I can look at someone's criminal history usually and be like, you're going to get a work with supervision, you're going to get a work without supervision. And I think usually what happens is the longer someone's criminal history is, the longer it takes, right?
Sure.
And then sometimes those really long ones, it's because they have out of state stuff that there's reasons that it takes so long. Like, no, not too much shade to the department. Like, I'm sure it's not in the bottom of a drawer somewhere, I'm sure. But
have you had anybody who was not allowed to work for an extended period of time while waiting for a request for reconsideration?
Generally not. That's a different letter that comes that says, because they're permanently disqualified, and it just says, like, this person can't work, please remove them from the building.
So it's almost like if the person's going to get a hard no, it's going to come within the time frame. If they're going to get a like soft maybe, then
with supervision.
Yeah.
Yep. And probably yes, but we need more time to like dig a little deeper. Then it's like, yes, you can work. We'll let you know when we figure it out for sure.
Well,
but rarely within
assuming we don't have the ability to radically change DHS's staffing, and also taking into consideration that a bunch of the recommendations from the other subcommittee are designed to just reduce the amount of disqualifications altogether and ease some of this burden. But so, like, thinking about those two things, do we feel like what DHS is doing as a, kind of a triage coping strategy right now is, kind of what we would want them to do anyway? I mean, if we assume that they just cannot turn around these in time, then it sounds like what we think that they're doing is they are trying to pick out the ones that are most significant, where they're going to have to deny somebody outright, and doing that quickly, and then trying to make accommodations that let people work so that they're not, so that they're leaving that door open on the ones that take a lot more time. To me, that doesn't seem that bad, but maybe I'm not looking at it right.
I feel like, so if I was going to make a recommendation here, it would be that, like, the DHS response times for final decisions, there needs to be some additional statutory, like, these are great for initial response, but like they can't take a year to get back to us. So like,
at some point it's putting it on the department to say, well, then you need to hire more people or whatever it is. So, because here's your statutory deadline.
Yeah. So like the final decision needs to be made within 120 days. Unless there's, right. Like,
although I guess my only worry, and this is just sort of plain devil's advocate, is that if we put 120 days or we put 90 days or whatever it will be, are they just going to automatically assume for every case they have that long?
Sure.
Like, I'm just sort of thinking out loud, like, and I don't know what that would look like, because I don't want all of a sudden they're just taking 120 days on everything that you don't really need to take 120 days on.
Well, maybe we codify that if the agency can't make the decision, a final decision on the set aside within these allotted times, that the agency takes steps to ensure that the applicant's ability to work isn't interrupted while the agency takes more time. So kind of codify what they're doing. And then I think we could also say, and then they should have a final decision within 6 months or whatever, or 3 months.
Yeah. Well, and hopefully by, if we get rid of the POE, that's, however many fewer they're having to do. Yeah. If the DQ subcommittee, if we can reduce some of those crimes, that's fewer. And I think, we also made some recommendations a while back about maltreatments, one of which I think would have directly impacted Shonda to her benefit, because one of our recommendations was that assessments cannot even be used in that reoccurring. And so I think there are maybe some recommendations that will hopefully be coming out of this to help clear that backlog.
And I feel like this one, if we get rid of POE, because sometimes what takes really long, the department said that, is waiting for records out state, and they can look at the crimes out state, but if they're waiting for records to come to look at POE, they wouldn't need to do that anymore, right? They could just look at the charges and decide, right?
Yeah, right.
And so I think that if we get rid of the POE, that would clean this up too.
Yeah.
And please just maybe I need it broken down a little bit more. Are we saying in regards to the time frames that even though according to statute, there's a certain time period for review and for process, and even though the department is not adhering to that for whatever reason, right, that's just okay, but then it's rigid accountability for the constituents if they're not adhering to the times listed in the statute?
I mean, that's kind of how it's working right now. We're suggesting that it not be that rigid time frame for the applicant, the constituent either.
But that's what I'm saying. If we can't find a resolution or a remedy in regards to if the department isn't following the timelines, then we should go to the other end of the spectrum to state that there should be time given to constituents. The department should not be able to be so rigid to constituents then, if they can't be held accountable.
Yep, and we are making that suggestion. That's the good cause exception part that we have up there. Is basically it's under timing for appeal, good cause exception. That's the idea behind that one.
And I think also when we also built in that the time for requesting reconsideration doesn't start until the reports are provided. I think there's a few pieces in here where I think we genuinely want to give the people who are the recipients of these more opportunities. And I think also at the same time, there are certain things that are outside of the department's control. We do have to acknowledge that we do have to acknowledge that if they're trying to get records from out of state, they're relying on other agencies. And so, but I do think I like this requiring a final decision within 6 months. We can recognize that they only have so much control over other agencies, but we're building in other pieces to try to actually help the people who are affected by this.
Okay. We all know money talks. Why can't there be something in here where the department is fine if they're not responding within the time frame that the statute says? I mean, we're talking about they're not adhering to the statute. They're not adhering to law. And it's okay.
They actually are adhering to the law though, because the statute simply says that they respond within 15, 30, or 45 days, and they are responding. They're responding with a letter that says that they need more time and the person is able to work. And so.
So what about there being a recommendation with that language to be changed? That it's not responding, it's being able to come to a decision.
That is what we're saying. That is what we're proposing. We're saying that they have to have a final decision within 6 months. So we would be recommending that a final determination has to be made. So that's the recommendation we were just talking about.
So, and again, I apologize, I need to break this down a little bit. As the statute is currently, the verbiage is current in the statute, they have the 15 days to respond, and then what's the time frame to make a decision currently?
There isn't one. And they can't, because of the Adam Walsh and child care block and all that stuff, like they have to do their due diligence with other states and all that stuff. That's all federal law that passed. That's part of the difference between the data that we received from 2018 and 2019. That's a requirement that they do all of that stuff, that they do their due diligence on that. And so like they have to try.
Okay, thank you.
Okay. I have another meeting that I have to hop on, my exec meeting for March. And so I read through all of this, and the rest of this, all I think I understand. The one thing I just want to point out again, the traveling set-asides, the department said the reason they could not do the traveling set-asides is because the FBI won't let them transfer information from one agency to another agency, that there's some kind of privacy act or something that doesn't allow. That's why it worked for a little while and then they shut it down. And so we can put that in there or whatever, but they were pretty clear that it didn't work, not because of DHS, but because of the feds.
Okay.
And so just FYI, I don't know if there's a different way to do it. I don't know. The one thing that I would say though, instead of this or in addition to this, is there a way for us to fix the problem of we can't even move somebody from one position or one building within our same organization? Like, forget traveling from one org to another. We can't even move somebody within our organization from one place to another without having to do an additional set aside. And so how do we fix that? That's not even moving the information from one place to another. And so how do we fix that? And that's not just Teen Challenge, that's across all of the providers are finding that. Lutheran Social Services, like if they want to move them from one position to another position that has a whatever. So I don't know how to say that, but it's a huge issue.
Yeah. Okay. I think we can come up with some language for that, Gina.
Okay.
Yeah. I don't know that it needs to be a traveling set aside. What we need is some way for DHS to be able to make a one-time decision that applies broadly to similar types of employment, so that they
how does the set aside itself stay with the person instead of the licensees?
Yeah.
How do we change that system, right? That the set aside is for the person instead of
it just seems like especially if you're looking at it, the same employer, like, just seems like there should be that umbrella.
Mm-hmm. Where they can just look, and especially with the rat backs, can't they just look and make sure that person hasn't committed additional infractions or like crimes or conduct, and then on with the show, and it doesn't take 6 months? Gosh, Randy's had 6 of them and they still take 2 months for him to get. Not anymore. It's a little better now. They made some
Yeah.
kind of adjustment that it's a little better now, but his first couple, it's like,
Well, and I also wonder, I mean, one of our recommendations, I'll remember one very early on was that like background studies for people in the chemical health field, you know, that we only use the Adam Walsh where you actually have to use the Adam Walsh. Otherwise, we had a different standard. So I wonder if maybe that will also help too.
mhm, yep.
But just a thought. I mean, but I do agree. It just seems like logically speaking, why isn't it the umbrella, which is the employer?
Yep. Yep. All right. I gotta
Okay.
go. Bye,
No,
you
I
guys.
gotta,
Thanks.
it's good. All right. And Tashonda, was there anything else? Because I know we had originally only planned for half an hour and I do, but we need to have quorum. Was there anything else here that you felt needed to be added? Or otherwise I think Gina approved and we'll go from there.
Yeah, no, thank you. I think just making sure we include definitions, just in regards to what Mr. Esme had pointed out about the good cause, wrap back, set aside, that those definitions can be included.
Yeah, that's a good point. This is all just like my work, my like shorthand and stuff. So when we finalize this, we'll do a better job of using clear language.
Yeah, I agree with that. And just so you all know, Will very graciously offered to start putting together a PowerPoint of all of our recommendations. And so to be presented to the large group. And so that's definitely something we'll want to do because our group, I mean, honestly, I think of all of the groups, our group has the most recommendation because I think we've just quite frankly like looked at so much. And so the PowerPoint will be summarizing all of our recommendations, you know, going all the way back to February. So Tashonda, I think that's a really good idea to make sure when we're presenting to the large group that it's understandable and that it's got the definitions so that everybody there can understand.
And one more suggestion, I wonder even if it would behoove us to include just what the statute of limitation is regarding discrimination, just the timeframes for that, that would be included, just so that people are fully aware of their rights and timeframes that they have for requiring accountability.
So you're saying like in the disqualification letter itself, it would have the statute of limitations? Because right now it comes with the appeal process. Okay, I hear you. And I guess I may have to check with somebody who does that because I don't know, and we'll have to probably get somebody else to figure that out so that and maybe all the language is just that there's a recommendation that's included. But that's on then the department to verify that statute of limitation because I don't know it.
Yeah, I do know it's 300 days, but yeah, just that's clear.
Okay.
Yeah, thank you.
All right, well, if there's nothing else, I think we can declare that all of these are, recommendations, but we'll obviously put them into a more final and, bulkier. At some point, I think the large group is going to have to figure out actually writing all of this, but our group will start with a PowerPoint that summarizes everything.
Thanks for that, Will.
Yes, he volunteered and I very happily said yes. All right, perfect. Well, if there's nothing else, thank you everybody for making time today. I really do appreciate it. And hearing nothing else, we're adjourned.